Good afternoon, ladies and gentlemen. We're going to get started. This is our Government Operations and Fiscal Policy Committee meeting. We do have a work session to consider two bills. The first one is Bill 28-18, Boards, Committees, and Commissions. These are amendments. As is stated on the packet, there was a public hearing on September 18th. There were no speakers. This is a bill that was sponsored by lead sponsor, Council President Reamer, at the request of County Executive. This bill will reduce the membership of the Cable and Communications Advisory Committee from 15 members to 9 members and increase the number of veteran representatives on the Commission on Veterans Affairs and remove the Director of the Department of Economic Development from the Commission. It also changes the name of the Committee on Hate Violence to the Committee Against Hate Violence. First committee that I ever served on in Montgomery County back in like 1991, by the way. So I'm glad they're making that change of the name, or at least proposing that. I think we're doing the right thing. And the executive originally transmitted 3 separate bills, but agreed to consolidate the bills into one omnibus bill, which is before us. And Ms. Myhill, anything else you'd like to discuss? It's pretty straightforward, but
Nope, you said it all.
my colleagues.
Based on that, I'm in favor.
Any comments or any objection? All right, without objection, we will adopt the changes that I think are quite timely and make sense. Okay, great. So the next bill is expedited Bill 2718, Taxation, Development Impact Tax for Transportation Improvements, Refunds, Credits, Amendments. And this is a work session. This Bill 27-18, Development Impact Tax for Transportation Improvements, Refunds, Credits, and Amendments was sponsored by lead sponsor, Council President Reamer, at the request of the County Executive. It was introduced on July 17th, and a public hearing was held on September 11th, and there were 3 witnesses. And so this bill would, number 1, authorize a transportation impact tax credit for certain expenses paid by a property owner for improvements listed in a Unified Mobility Program or the White Oak Local Area Transportation Improvement Program. Number 2, it extends the time for the county to spend transportation impact taxes to equal the time transportation impact tax credits remain valid. And 3, change the time to certify an impact tax credit from the issuance of a building permit to the collection of the impact tax. So that's what is contained in this particular bill. And with that, I'm going to turn it over to Mr. Drummer, and I will also have Mr. Orland here and DOT as well. Mr. Drummer.
Thank you. The major part of this bill is dealing with impact tax credits in a limited situation. Under current law, a developer receives a credit against their, well, we call it the LATIP, but it, what does that stand for? That's the Local Area Transportation Improvement Program, which actually I think is limited to White Oak at the moment, or the UMP fee, which is the Unified Mobility Program, which is something that we haven't quite started yet, but is planned to be started. And there, if you build something that's in one of the listed improvements for that local area, you're entitled to a credit against what would otherwise be your LATIP or UMP fee. You're also entitled to an impact tax credit if the cost of the improvement exceeds your UMP fee, but is still less than or does not exceed the listed cost of the program as it's set up originally. That leaves a situation where someone's...
Yeah, can I interrupt? It's not quite that. It's...
Okay.
No. just this part of it. Don't get back to the legal part in a second. The first part of what Bob says is correct. If the LATIP fee is $2 million and the improvement is $3 million, the developer gets a credit against the full LATIP fee, doesn't have to pay a LATIP fee. However, if the listed cost of that improvement is $5 million, In that situation, he would not get a credit against his impact tax. If it were greater than $5 million, then he would get a credit to the degree that it's above the $5 million. So that's the way the law works now, and what the Duffy companies who are asking for this bill is asking for is that the credit be applied to anything above the late tip fee. So in other words, in the example I just gave, he would get a $1 million credit against his impact tax, as well as the $2 million credit against his late tip fee. Now, I just made all those numbers up. We have no idea what the cost of all these improvements are going to be, or what the late tip fee or what the impact tax are. But presumably, what the Duffy companies are going to be wanting to do is more of an improvement than what the late tip fee would be. And so he's trying to get a credit for not only the full credit against the late tip fee, but the incremental credit against the impact tax, which he would not necessarily be able to get, since the improvement he's trying to do is not greater than $5 million. The $5 million, by the way, I didn't make up. That $5 million, the $5 million is the listed cost of the Powder Mill Road improvement in the late tip program that you approved a couple years ago.
Council President Reamer.
Is this because the actual cost of the project wasn't estimated properly, or, how does this
Mr.
arise?
Conklin.
This particular cost is a placeholder number. It's actually the only project in the LATIP that's a placeholder number. Everything else has a defined project attached to it. And the improvements that might be contemplated here are around $2 million rather than the 5, and their obligation for payment, both impact tax and LATIP, is around that $2 million. So we didn't actually realize there was an issue here until we went to try to work out the structure with him, and identified that there was this problem that if the fee or if the estimate is higher than the actual cost, they might not be able to get the credits that we think were envisioned under the bill as it was passed.
I mean, it could come up in other situations in White Oak as well, or future umps, because, all the estimates that are done at the time we produce the program is just that. It's an estimate.
Every year they change. And
But Chris is right. That particular improvement was by far the softest estimate. It was really kind of just looking at the intersection, figured, well, about what do we think we might be spending on something that we didn't know what it was going to be in particular. It could have been a bunch of turn lanes. It could have been the slip ramp, the Elton Road, to the interchange. Could have been any one of a number of things. That's why it was
So
left
again,
that
just to
way.
make it really simple, as current law, you can't get any refunds for expenses above the amount estimated in the mobility plan. That's the problem.
No, you would get credit if it were above the amount estimated. The issue here is that the estimated amount is between what they owe an LATIP fee and the estimate. So they're in this weird middle space where they don't qualify for the impact tax credit.
What this would mean is that they would get a credit, which, of course, the more of a credit is given out, and for any reason, the less funds are available for the county for the full CIP. It's not really just for transportation, it's for everything, because in the end, as you know from reconciliation exercises, almost all the money is fungible. On the other hand, if he is actually going to be building the project, then we'll get the project done much sooner than we would do if we were just collecting the money and waiting until we had enough money to do it. So there'd be the benefit of actually having an improvement out there probably many years sooner. And they would argue also that it would be done more cheaply, or less expensively. Not to say more cheap, with less cost.
Same quality. Okay.
That's fine. So that, Glenn just explained the policy issue. It's getting the improvement done sooner. It would cost us some loss in impact tax revenue that could otherwise be used elsewhere. And the executive is recommending this. The council staff is also recommending it. We believe that it's a reasonable way to go, and that the fact that we get the improvement done sooner and possibly cheaper is worth the loss in impact tax credit. So that's actually the major part of this bill. The next two issues is well, the first one is the time that the impact tax credit, the time the county has to schedule the expenditure of the impact taxes. is currently 6 years, but the impact tax credits are
12.
alive for 12, and this would just make it consistent with 12 and 12 years. The last issue is the time that the county has to certify the impact tax credit. Under current law, it's supposed to be done at the time the building permit is issued. When that was written, people paid their impact tax at the time the building permit is issued. There was a later change in the law that extended that time period to either 6 or 12 months after the building permit is issued, depending on what type of building permit you have, whether it's single family or commercial. And so this bill would then make that consistent also, that would give the county, would require the county to certify the impact tax credit at the time it's actually due and payable. And those are the three things that were in the bill as it came over. And then
So let's pause there for a second. So are there any concerns, questions from my colleagues on those items?
I'm very comfortable as the bill was written. I think this makes sense, and I think it's a sense of fairness, and I think that's what we're doing.
I'm good as written, yeah.
Yeah, I think that I agree that these are important modifications, I think especially as we're going through the White Oak redevelopment project and, you know, the conversations that we have had time and time again with the community members regarding infrastructure and how do we get that done sooner or later, et cetera. I think this definitely makes sense, so I would add my agreement to my colleagues. Okay, just one more item.
the last issue in the bill is a little more complicated, and I'm going to let Glenn and Chris explain this one. This is a request from Barb Harris on behalf of a client with an individual project to add an amendment to the law which is not actually about directly related to the three things we just talked about, although it is about impact tax credits.
And Bob is here, of course, if you would like to speak with him at some point as well. What Mr. Harris is asking for is that the law be amended to say that any capacity which is required and is designated as stipulated as capacity that's required by a subdivision approval by Park and Planning should be automatically creditable against the impact tax. That's really the nub of it. The background of this is that in 2008, the Cabin Branch development in Clarksburg, which is the particular development we're talking about as Mr. Harris's client, came in for subdivision, and one of the requirements of that subdivision was to widen a 3,000-foot section of West Old Baltimore Road from about the point where West Old Baltimore goes under I-270 west over to Route 121. Basically, it's along and even within the southern part of their development. West Old Baltimore Road now is a 18-foot wide, 18 to 20-foot wide road. It's a rural road. The lanes are very narrow. And what the required is here is that the road be widened in that section to two 11-foot lanes and two 4-foot shoulders, a total of 30 feet, which would be building it to arterial standards. The Clarksburg master plan calls for West Old Baltimore Road to be an arterial from 121, not only over to I-270, but all the way over to 355 in the southern part of Clarksburg. Typically, in fact, I believe almost entirely, up until the point that this subdivision was approved, in fact, up till now, DOT has not given credit to an improvement which just makes a two-lane road a standard two-lane road.
How many of those have there been?
Yeah, we don't. It comes up regularly. I wouldn't say it's really common, but for example, a good part of Clarksburg, for example, there are a lot of roads that were two-lane roads that were developed to basically standard roads. Shawnee Lane, Skylark Road.
And no credit was given?
No.
Credits were given when these roads were expanded from 2-lane to 4-lane roads.
Right.
For capacity. generally given for bringing a road up to the base standard.
Right. Now, when the subdivision was approved in 2008, the planning board, in their agreement, and then Mr. Harris brought this to your attention as well as to us, said that that section of road needed to be widened to meet the policy area view capacity in Clarksburg. If you recall, prior to a couple of years ago, we had two tests in the SSP, policy area review and local area review. Policy area review looked at the total amount of capacity in the policy area as a whole, and it was measured by what we call link capacity. What would a two-lane section of road carry? What would a four-lane section of road carry? What would a six-lane road carry? And depending on the type of road, whether it's a freeway or arterial or a business district street, it would be different amounts even per lane. However, it was also would have been required anyway, even if there was no policy review problem, because routinely park and planning requires developers who are building, taking an existing road and having this road now serve that subdivision to bring it up to county standards, whether or not there was an SSP issue or not. At the same time, actually, this was happening for different reasons. The council was amending the impact tax regulations, and that went into effect in July of 2008. And those regulations explicitly said that a road like this that was widened to a wider two-lane road is not creditable against the impact tax. And the reason why that came up is because, like often happens with regs, the regs are brought over because there are a lot of issues that developers bring up which were not very well defined in the law or in the previous reg. And so this was a common request up until 2008. And so DOT thought to clarify it by saying, look, if you're adding lanes, yes, you get a credit. If you're not adding lanes, you don't. And that was adopted by the council on July 29th, 2008. The subdivision case that for Cabin Branch went before the planning board in April of 2008, but the final approval of the subdivision didn't happen until October of 2008. So, it was one of these things where, in fact, by the time subdivision was approved, it was already known that this was not going to be creditable. Now, it was under the current law. Again, we would maintain that this is not adding capacity. DOT has really never given credit for this kind of thing. They sent a letter to Mr. Harris earlier this year saying here's a list of things in the project which were creditable, and they recently, after thinking about this some more and looking at the project more carefully, came back with a second letter, which is in your packet, which is actually much more, includes many more items that's creditable. For example, one of the things they didn't have in their initial credit letter was what they said was that the bikeway that was built next to it, the hiker-biker trail, was not creditable, but it was, they realized after looking at this again that the law does allow a credit for a dollar-for-dollar credit for building a bikeway. And so they're now saying, yes, that is creditable. Same thing is true with the sidewalk, I believe, on the south side of the road. It's a connector from the neighborhood to bus stops and such.
Because the SSP requires you to make improvements for pedestrian and bike transportation. That's one of the things that's a little stronger in the current SSP.
That's correct,
as well.
and these improvements are consistent with the master plan recommendations. So we've expanded the credit that we think is eligible.
Right. And they've even, there's still, no matter how often or how tight you draft regulations, there's always going to be gray areas, right? And so I think what they've done actually in this case, this latest letter, was to be, basically give as much credit as they feel like they could possibly give under the current law to Cabin Branch. So for one example is, at the intersection of West Old Baltimore Road and Broadway Avenue. Broadway Avenue is a north-south arterial that runs through Cabin Branch. There are turn lanes that have to be provided, additional lanes. Well, that was always going to be creditable. But what they're now saying is that the 600-foot section of that road, which is sort of the influence area of those turn lanes, in other words, where you have to start building acceleration lanes and deceleration lanes for the turn lanes, they're saying, well, you probably have to rebuild the entire road in that section anyway, so we'll give you credit for the whole 30 feet, even though you're not adding through lanes on that section, but because you have to reconstruct the whole thing, we're going to give you credit for all that, for that section of it, 600 feet. That's just about 1/5 of the length of the project. And there are a few other things which are, you could go either way, and I think they've erred is the wrong word. They've judged on the side of, I don't know why, judged on the side of actually giving as much credit as possible. And this is my estimate. My estimate is probably somewhere between 30 and 35% of the cost of what this improvement will be creditable. So our recommendation is not to include this in the bill. We feel like not only in this case it's not really justified, but if it is included, it would have an unknown, but we think somewhat significant effect on future revenue, because this is not an uncommon situation, particularly when you're building in greenfield areas where you're like Clarksburg or even some other areas of the county which are still building out. Taking an old road, which was never meant to be serving a subdivision, and bringing it to county standards, and then saying, okay, all that's creditable, where in the past it's never been.
Planning here?
Don't know.
Mr. Harris, would you like to
don't think so.
address?
Thank you very much, Bob Harris. Okay, thank you. Thank you, Bob Harris, for the record. Appreciate you giving me a brief opportunity to speak here today. I agree with some of what you've just been told, but I'm not sure all of it was fully correct here, and may be that I've lived with this project so long that I have some other knowledge that others don't. And the reason it's important to us is that I am afraid that, without this clarification, we will get only a small portion of the credit that we've expected since day one. I know Glenn speculated that we probably didn't expect to get credit for this, but I can tell you we have expected to get credit for it from day one, and I was shocked when we got the initial letter from DOT saying that they were only going to give us, token credit really for some of the peripheral things. So it is important. I'm not familiar with the other Clarksburg instances where two-lane roads were taken two-lane roads and people didn't get credit. In fact, the only one with which I'm familiar was a two-lane road that did get improved, and it did get substantial credit for being a new two-lane road. But irrespective of that, to me, it's only fairness, as I've communicated to you in writing. We were told we had to do this road improvement to add transportation capacity. There were no two ways. It was in plain English. And for a government to now say it doesn't add transportation capacity is, just, incredible to me. I think the code needs to be corrected so that if you are required to do something to add capacity, you can get credit for it. In their staff report here, staff correctly points out that it is useful to have private developers to build roads that benefit the public. They're done more quickly, they're done more cheaply, and that's what's happening here. This is a master planned road. It isn't going to get built but for us. And so we're benefiting the public by doing this, and we should get credit for it. I have to clarify what Mr. Rowland was saying. He was partially correct in it. Sometimes developers are required to do road improvements that aren't being done to add capacity. But under the subdivision regulations, those are referred to as frontage road improvements. And if my property fronts on a road and I'm going to have lots that connect to that road, I need to upgrade my half of the road. If there's no curbs and gutters, I need to put curbs and gutters on my side of the road. If there are sidewalks normally called for, I need to put it on my side of the road. I don't need to touch the other side of the road, and I don't even need to widen the road beyond the center lane. But that's not what this is. We have no lots that front on West Old Baltimore Road. This road requirement was 100% required because of the policy area transportation review capacity issue that Mr. Rowland spoke of. And that's why it, unlike perhaps some others, is creditable in my mind. We could get into the weeds as to whether it adds capacity or not. to me, and I'm no traffic engineer, but we have our traffic engineer here, he can explain chapter and verse as to why it does add capacity. If you're not willing to accept the planning board's calculation, that is what this is all driven by. But to me, it's simple observation. If you look at West Old Baltimore Road today, and I brought a couple pictures of it, it's a narrow, little winding country road. I'm sorry. One of these, the top one is West Old Baltimore Road. The other one is Maryland Route 355 in Clarksburg, also a two-lane road. And, you know, to me, it's simple observation that West Old Baltimore Road can't carry the same capacity, same traffic that the two-lane 355 does. That's effectively what we're doing here. This road is going to be a beautiful road with bike lanes, et cetera, and I just think we should get credit, so
Thank you. Thank you. Yes, Councilmember Katz then.
Thank you very much. Bob, do you have a copy of the letter that actually they sent?
Yes,
Well,
sir.
Not that I need it, but
I do.
my point is that if you meet the definition of capacity, then you should be getting credit, not because of new legislation, you should be getting credit from the old legislation.
You are,
So if
you-
that's,
yes.
so that's not part of, to me, that's not part of this legislation. That's part of the discussion that you should be having with the people that are saying whether the credit should be there or not. And
Fair point. That's where I was in May, June, July, and August. But then when they kept telling me, no, we're not going to give you credit other than for this path or this part of it and not the whole thing, which is what I think the law says. Well, I said, well, then you must be reading the code differently. We need to clarify the code so that the next Bob Harris doesn't get caught in this trap. And, you know, yes, in fact, I'm scheduled to meet with these gentlemen later this week to try to work out our particular issue. But I'm not guaranteeing that that will work out in a fair way, and I'm not guaranteeing that the next Bob Harris isn't going to be here before you at another time. This looked like a convenient time to do it, Mr. Katz, that's why.
well, and in my estimation, this legislation really does not fit what you're suggesting, but the first part of the legislation. I understand you want the amendment, but the first part, and if that's the case, and after all the discussion, and if others agree or disagree, whatever, and there's separate legislation, that's another discussion. But I don't believe this fits what we were trying to fix with this one. That's where I am. And I understand that there's a fairness issue, and we can all talk about safety. Maybe it does create capacity, maybe safety doesn't create capacity, whether or not you have other access into your development, even though you don't, it's road frontage. It's my understanding the entire 3,000 feet was road frontage that you all, of your property, right? Was it beyond your property?
It is beyond our property in some respects, but a
Well,
lot
if
of
that's
it
the case, that should be part of your discussion with those that discuss it. But to me, we're mixing apples and oranges for this legislation. Thanks.
Yeah, I mean, part of the reason why I think it's important to hear from Mr. Harris, of course, and have this conversation is obviously what we want to do is make sure that things are very clear. And so, you know, my reaction was that we definitely have a bill here that has certain components that we need to address. But having, you know, heard Mr. Harris as well as our own staff and as well as Mr. Conklin from DOT, it seems to me that it would be useful to take a look and ensure that whatever ambiguity is present, that it be sorted out, because we do not want this to come back in the future. And so my take on it was, indeed, if all of you can get together, you know, and then if the T&E committee would like to take a look at this, and perhaps there could be a bill that specifically clarifies all of this. Because, again, my only concern is that we are the GO committee. We deal with specific issues around tax. We don't necessarily deal with a lot of the technicality of what constitutes what and the timing of it necessarily. And if it is something that needs to be clarified, perhaps it's important to take a look at it from the lens of the T&E committee, which deals with that portion specifically. And so, you know, that was going to be my recommendation to the committee, was that let's take a look at this, because I do worry that it's something that can happen. Conversely, I don't feel comfortable making a decision, although we don't have it in front of us as an amendment, but even making a decision, because if it sets precedent and we don't have that information regarding fiscal impact, et cetera, then it's just making a decision without that kind of information. So that was going to be my offer to, to the committee, that I think we should, can send a memo to the T&E chair, and this can perhaps get worked out separately. And then indeed, if there's going to be some modifications that need to come to the GO committee vis-a-vis tax, we can take that up. Council President Beamer.
Thank you. I think this bears a lot more examination, so I would like to know what roads have been provided credit in the past and which have not. And I generally agree with the chair's point here that, it doesn't feel like enough deliberation to kind of, if we were upending 30 years of decisions, or changing the decision after however many years, and that there have been numerous examples in the past, I think that would be a fairness issue to everyone who had come before as well. So it just seems like we have to do some fact-finding here to understand really what we're grappling with. And I wouldn't want to do something that, costs us school construction dollars and, other kinds of dollars, when in fact it's not that different from anything we've done in the past. On the other hand, if, it seems problematic that the planning board, I suppose, used the word capacity in its language about this. Chris, can you comment on that?
Well, the planning board has not drafted their language with the notion that their language is interpreted to determine impact tax credit eligibility. They're looking at these from a broader perspective, not the specific elements of adding, a lane here or there. The language from the program, the PAMR program that was in place also October of that year, refers to addition of lane miles to address the requirements here, and there are no lane miles added on this road. So I'm not exactly sure what their determination of capacity was. We have to look into those matters. As others have said, this is completely unconnected to the purpose of this legislation. And I think you're taking a wise course by trying not to embed it. And with Mr. Harris, we have a long way to go in terms of figuring out the design of this facility, what elements are linked to the improvements that we think are eligible, and ultimately what credit is received. And we're happy to do the research you suggested on how this has been treated elsewhere.
That's helpful, because I just think, as far as the chair's comments, I wouldn't want us necessarily to seem to say to T&E, we think there should be legislation.
Well, my point is that this, to me, is outside the purview of GO. So I would like to communicate with T&E that this has come up. It was brought up in this context, so that they can address it, whether it's legislation or whether they just need to clarify some language that can be done through regulation. I don't know. But I think they should take a look at this, and then if we then have to come back and address the particular issue about the credit vis-a-vis, tax, which is our purview, then we can do that. But this was just, it seems to me that, for us to here in GO try to get into a lot of the technical issues around capacity, what constitutes capacity, et cetera, it's a different committee that deals with that directly.
I'm sorry.
And I just wanted to be noted that if, I'm using the word if, that does need legislation, as far as I'm concerned, this should be literally fast-tracked. I mean, if there's a fairness issue here,
Yep.
T&E, and, not to tell them what to do, but they should take it up as quickly as possible, and so that we can get this resolved for all parties involved. But I just don't think there's a connection on this piece of legislation.
Yeah.
Well, the question I have is just in terms of process. There's two ways you can go. Since the committee seems to be fine with the basic bill that was introduced, and we have a fiscal impact statement, all that, we can move that bill for action and approve it, and then ask for a separate bill to be introduced for Mr. Harris's proposal.
Again, I don't
He'd
want
need a
to ask
sponsor.
for a bill to be introduced, all right? I'm not convinced that a bill needs to be introduced, but I think that this issue needs further exploration.
Okay, all I'm saying is if you do, which is fine, but that may hasten our decision towards Mr. Harris's issue, but it'll slow the issue for the
Well,
Duffy.
my intent is to,
I know,
as chair, my intent is to vote on this bill because we don't have in front of us any particular amendment. But as a courtesy to the fact that there seems to be some ambiguity, what I am offering is that you should send a memo to the T&E committee to describe what happened so they can take a look at it. I don't know that they're going to need a bill, because maybe it can be worked out. Maybe there is nothing to work out. I don't know. But I think that this is squarely in their, in their portfolio of policy area. If a bill is needed, I agree with Councilmember Katz. I think that we should try to do an expedited bill to address it. But my goal was for us, and I think that, there is no objection to what's contained in the bill as introduced. We're going to move that and then approach the T&E committee.
All I'd add is that it's clear that if we do what Mr. Harris is suggesting, that will require legislation.
Okay.
Because the law, as written now and with the regs,
I think
make
the
it very
T&E
clear that
chair
it's
can,
not.
right. But I think that with all due respect to Council President, the T&E chair can hopefully make that decision, although you're a member of you're not a member of that committee. But the T&E chair can make a determination as to, how they should proceed, I'm sure, with your advice. So,
Okay, so my understanding is you approve the bill as is. Do you want to
the
have it
bill
then
is,
go?
we're going to draft a memo with your help.
Draft a memo, but hold off on scheduling action until we hear back from TNA?
No.
No.
No, we're
Separating
moving forward with this
positions.
bill.
So you want to go ahead and move, ask TNA to
Yes.
look at it, but go ahead and approve the bill as is?
Yes, communicate to Tinny what the conversation was, which I'm sure they can also watch the
Sure.
video. And that, that we would like to request that they address this issue appropriately.
All right.
And if GO then somehow has to chime in, I guess we will, but I don't know how that will work.
Madam Chair, thank you. I think that's an appropriate approach. I will work with them and resolve this.
Thank you. Okay, so it's a 3-0, and we're done.
We're 3-0 with GO.
Well, 3-0 for GO. All right, thank you very much, everybody.